As you may be aware, or because of your background may not be aware, I fortunately had the opportunity to come in the fire service about the time that the 1910.156 Industrial Fire Brigade Standard was being developed and being handed off to the fire service. South Carolina in the mid-'80s received this standard, which created a lot of conversation and created a lot of concern. And over the past 40 years has caused us to develop and enter into a lot of the things that we're doing now. The 156 standard has been the backbone of most all of the safety things that we've done. It's what we fall back on. It's what we rely on. And the association is very much in favor of keeping a robust safety environment, a safety atmosphere, and developing a good safety reg for our state and for our firefighters, for our members. Supposedly, over the past 17 years, this 156 regulation has been going through a series of transformations, writings, participatory conversations amongst national level organizations. And I say the word supposedly with intent. And it's not to draft shade, because I know that there were meetings and work going on, but quite frankly, at the association level and at the national levels of the agencies that I have participated through the years, in those 17-year period, we never saw anything. We never heard anything. We never had the opportunity to see what was being worked on by these groups to update something that definitely needed updating. If you're familiar with the current 156, you'll know that it's archaic. It's really industrial fire brigade standard. So it needs updating. But we didn't see anything until late December-ish of 23. In 23, a document was offered, an introductory that, hey, this is coming, we're going to publish this, it's a new standard, get ready. When in the beginning of 24, we got our hands on it, it was a 600 plus page document that had the standard itself with an incredible amount of added description, narrative, explanation as to what the thought process behind it was. Reading that 604 page document in early 2004 scared me and a great deal of the fire service of this country. Many parts of that 604 pages, many parts of that proposed 1910-156 that was being presented to the fire service was things that we had, quite frankly, been doing in this state for many years. Some of it just simply wasn't anything really new. It was just codifying it. It was putting it in a regulation. But some of it was drastic. Some of it was so drastic to the point where it was not beyond the association saying that when that federal regulation, as it was proposed, or as it is proposed, was to hit the street, probably 2/3 of the fire service of this state wouldn't be able to meet it. And that there would be a large part of the fire service of the state that would be simply have to make an existential decision about, do we just go out of business or do we just ignore the standard? Because you're not going to be able to comply. I think that proposed 156 was probably more so harsh on other parts of the country. There were other parts of the country that took a much more concerned approach, much more harsh approach, and voiced their opinion likewise. Most of the time, that's because of the fact when a federal regulation is written, when a safety regulation, when 29 CFR items are written, the local jurisdiction, the state, can outright adopt their plan, enforce the federal plan, be a federal OSHA state, or has an opportunity to write their own plan, a state plan. South Carolina is a state OSHA, a state plan entity. Our state has a OSHA department that's in LLR, within the same division that our fire marshal's office is. We have an OSHA director, Katrina Baker, who is just an incredibly talented, smart lady. And we enjoy, quite frankly, the ability to have at the state level OSHA regulators, investigators, partners, if you will, in the past 40 years, helping us get to the point where we are now with our OSHA regs. But with this proposed 600-page document was coming out, it became obvious in 2024 that the association needed to step up and take action on your behalf, on our members' behalf, to try to craft or direct the final stages of this OSHA proposal. It was going through the typical 7-step OSHA development process, and by giving this proposed wording out, they were in like step 4 and 5. And so we really only had some of the final opportunities to impact the contents of this regulation. The association got very busy in attending and testifying in front of groups orally and in writing. Those can be found, and we've shared with you, and we'll share again with you our web page where many of these things are located. But in writing and both in testimony, we drafted what we thought were our concerns, your concerns, and we offered alternatives to those in a number of forums, a number of opportunities. We then started an internal, in-house, smaller group of people to start talking with and dealing with this topic. Under the president's direction, a ad hoc working group was established here at the association office where we would start talking and meeting, and it became evident pretty quickly that because this new 156 enveloped EMS, industrial brigades, law enforcement, and special operations group, as well as fire service, that quickly we needed to have a larger working group, a larger subject matter experts, if you will, coming together to talk about the impacts of what this proposed reg was going to be. It was going to be equally onerous to many of the other ancillary agencies that operate on emergency scenes, and they needed to be involved. So again, under the direction of the executive committee of the president, we established a larger working group of persons from hospitals to law enforcement to private industry, fire service, EMS professionals from around the state, and we have met on several occasions to try to make sure that we are all of like mind and we are sharing concepts of getting us to a point where ultimately this state will have a period of time, no greater than 2 years, to adopt a state plan, a state regulation in response to what the feds may do. In 2024, we were going through an election cycle, as you may be aware, and many of our partnering entities made an assumption and were willing to politically theorize that because of the political platform of the Republican Party and then ultimately the individuals that won election in November of 24, that this reg would stop or would go away. It just wouldn't happen. We did not want to operate on that premise. We felt like that it was too important and too impactful. We wanted to get ahead of this thing. We didn't want to gamble that it's just going to disappear, because fundamentally, if under a Republican political party it disappeared, eventually, if Democrats were to come back into that position, it'd kick right back up again, which has been part of the history of the 17 years and why it's taken so long. It has proven not to be the case. Those individuals who said it was going to stop or going to go away have been proven wrong. The president has made his appointments to the Secretary of Labor and to the Secretary of OSHA, both of which are individuals who have labor-centric backgrounds, and therefore the process has continued with one small caveat I'll offer. There have been a few national level organizations which have gotten together to meet about this issue to see if there's some opportunity for compromise, specifically the differences between organized labor groups, which have a lot of representation in this proposed standard, versus volunteer groups, which will be most negatively impacted because of some of the contents of it. Those meetings are ongoing. I've not seen a lot come out in those, so I don't have a lot of hope for that. But we have agreed to participate in those and pledged our support to any kind of discussion or conversation. But fundamentally, at the federal level, 1910.156 is still rolling along, and it's still rolling along in its proposed language. The language you'll find from our website, the language that you may have already seen, it's still there. Nothing's changed. And so my reaction to that document has not changed, or the reaction to what it would do. It is complicated, and something that I want to go through with you a little bit that you need to understand is that we are very much in favor of this reg. clearly let me hear me say that the association is pro developing this rig, pro a revised and improved version. It needs to be. The 80s version of this is almost archaic, ridiculous at this point. But what we are concerned about is the impact on the majority volunteer fire service we have in this state. We have to be. It's over 2/3 of our state, as well as some of the incorporation by reference of NFPA standards that's found in this document. I would say that two things, those are the two big items that the association has taken issue with, and you would see in a number of our responses as you look through our material. One, the volunteerism. There are a lot of man-hour workload requirements in the federal proposed document that was really going to be impactful to the volunteer fire service. It's going to require the volunteer fire service to get incredibly creative, or quite frankly, hire people to do a lot of the planning and programmatic development and monitoring that was proposed under this regulation that people in rural South Carolina just are not going to have the money to do, and certainly aren't going to have the time to do. And so being able to develop methodology for that was our primary concern. Certainly not, I won't say secondary, but number two was the NFPA standards. This proposed standard incorporated 22 NFPA standards into the regulation by reference, IBR, incorporation by reference, which basically means to all of us, if it says it in the NFPA standard, it's now federal regulation. We've always been held to the standard of an NFPA reg in our training and in our response, how we equip fire trucks, but it's never been part of law. It's never been something that someone could come by and cite you for not doing it. Now, in a court of law, criminal or civil proceedings, certainly you're held to those standards by virtue of the definition of a standard, but never in a federal rig. I have an opinion. I don't know that that's going to hold up because I think there will be a number of legal issues surrounding incorporating by reference into a federal rig a nonprofit organization's work. I think that's yet to be seen, but our stance from the association was we needed to make it reasonable, feasible. I'll talk more about that word in a second, for volunteers, and they should drop the IBR of the NFPA standards. It only failed to reason. The proposed standard incorporation by reference has a lot of things that you're familiar with: 1500, 1582, 1710, 1720, 1010, on and on and on and on. Things that you know from just those numbers from your history and your work are going to be pretty impactful if somebody says, not just they're a standard you should be trying to achieve, but now it's the law, it's the rule. Therein lies the problem. Think about 1720 and the application of volunteer fire service and the number of responders and the response time dictates now that federal law will have for somebody in rural fill-in-blank county, South Carolina. It is problematic. In the proposed standard, privately owned vehicles are basically considered part of the department's rolling stock fleet and will be treated and handled as such and can be cited by OSHA if you have a violation in your personal vehicle. Fitness testing, not physicals. Now, we'll get around to that one, but fitness testing. You're going to be held accountable to every department developing a fit test, a wellness test, to be able to prove that your firefighters can perform the duties. Now, again, I said, like I started, the association can't be against that because that's a safety thing. And we all realize that, as one of our speakers, Dan Shaw, said at the conference, if you had the opportunity to be there, we're performing at the level of elite athletes. So we have to be for fitness and wellness, but now you're incorporating testing for that and eliminating individuals if they don't pass that test by law, not just by best practices. Physicals, I mentioned again, now we're basically under the proposed regulations expecting everybody to do 1582 physicals. Now, just that number alone, if you're not familiar with it, go do some reading, but I don't know if anybody in the state is doing it. A lot of people are striving for it, but I don't know if anybody in the state is able to do that or whether we have the capacity to do that for 17,000 people at this point. It goes on and on and on and on and on. So the proposed standard is pretty tough. We felt like it would be better if we took our subject matter experts, yourselves included, and develop our own state plan. Now, when you develop a state plan, it has to meet or exceed the federal plan. Meet or exceed the federal plan. So the first thing you should be saying, well, Joe, is how are you going to meet something or exceed something that you're already telling us is breaking our back? Good point. Hang on with it for a few minutes. I'm going to come back to it. The federal authorities look in the adoption process of the word feasibility. They are suggesting that you can discuss the reasonableness of their standard and proposed alternatives if something is economically infeasible or technically infeasible. If you can't monetarily implement something, tell us why. If you can't, in actuality, do something, put something together, part of this reg, tell us why. Feasibility is the big catchword. So we've tried to craft a document that is going to be feasible, being a keyword for us, but at the same time meet or exceed. How is that? Well, if the standard goes through as it is written, now again, I'll say I don't know that I necessarily believe that it will, but if it does, we will have to spend a great deal of time trying to justify what we do. But I think one of the things that's going to happen at the federal level that's been a big push is there is a large push to exempt volunteer firefighters from this standard. Exempt volunteers, create a different standard for volunteers from the 1910.156 to say volunteers don't have to meet it. We are not in favor of that. Hear me clearly. We are not in favor of deleting volunteers from it. You look back at some of the history of our line of duty deaths, volunteers aren't exempt from that. I mean, it happens. The volunteers need to be safe. I, as a volunteer, because that's what I do now, is I feel a little insulted by the fact you're telling me I don't have to be as safe, or I don't need to be as safe, or I can't be as safe, and that's not reasonable. So if you've created a standard that I can't even meet, I think you're creating me a different class of firefighters. That's not fair. We are not in favor of deleting volunteers. Now that sounds counterintuitive, because what I want to tell you is I hope they do exempt volunteers at the federal level. Now, hang on with me a second. Joe, you just said you're not in favor of it, but you hope they do. Well, if the feds exempt volunteers and go off and create some other type of document, immediately our state plan, what you're going to start working on here shortly, is going to meet or exceed what the feds are doing. Think about it for a second. They're going to leave out, in South Carolina, 2/3 of our population because they've omitted something. Right out of the gate, whatever I propose for all of our people, 17,000 people, will meet or exceed the feds. And that's kind of the strategy we're going with. That's a difficult one to understand, because superficially somebody said, well, just leave us out. Well, that's easy, but it's not practical. What I'm suggesting is if something is created that omits, we can get ahead of it and meet or exceeds. Because we want to perfect this document, all 5 subparts, and be ready for when the feds hand off their document. At some point in the near future, the feds are going to say, this is our proposed 1910.156. And at that point, when they do that, the state of South Carolina has 2 years to implement their state plan. We want to have a draft of our state plan vetted, run by everybody, certainly written, and have ready to go through our state regulatory process. We have a regulatory process for adoption of those federal handoffs, and we want to be ready for that. We don't want to be caught 2 years and then saying, oh, the time's running, we got to get these things developed. And we've got a really good jump on that. And I appreciate your participation, because you're getting us closer to the point of being able to have a draft that's ready for us to go. Now, eventually I see us establishing checklists that are going around the state so you can check off the things that are in that 15 pages. And at some point, I think that there'll be entities, whether it's the association or others, that'll do narratives, classes, programs, maybe even services to some departments to try to comply with some of the areas in there. I think you'll see some areas that people are going to need help with. Text anytime. I'll be glad to help you with questions. That's what I'm here for. But fundamentally, thank you, and we'll be talking to you again real soon.